Hello viewers, this is Major General Neelendra Kumar in conversation with Justice B.A. Khan for the playlist In Similie. The next question to you, Justice Khan, is relating to international commercial arbitration. Number of times demand has been raised and expectations and belief have been expressed that India should become a hub for the international commercial arbitration. Now, frankly, what are the problems and challenges with the view to fructify this national desire or wish?
I feel that we are not firstly doing anything to achieve this goal. Secondly, we are not near anywhere of making
this realization
our country a hub of our international arbitration. There are so many reasons for that. We had started this arbitration mechanism as an alternate dispute resolution method.
G.
The purpose was to lessen the burden of our courts,
G.
Where we had so many pendency and arrears. We thought we will resort to an alternative method and we will have speedy disposal of pending cases. That was one purpose. Second purpose was to bring it in alignment with the international standards like ministerial model and to give an image or an impression to the outside world that you are safe here in our country and your interests will be safeguarded and all that, and our enforcement is as good as yours. You will not suffer any loss or so on and so on. With these two objects, we had enacted that Arbitration Act of 1996. But what happened, General Sahib, is that in that Arbitration Act it was provided that under Section 5
G.
that court interference shall not be there in arbitration. No court shall interfere. But practically what happened is that it was back to the court again.
At different stages, on different pretexts.
No, it is all same thing.
G.
When I say that it's a duplication of a civil suit,
G.
or it's a duplication of our court system, but not only duplication, it takes double. G. If your matter is running in the court, if it takes 5 years, here it takes 5 years, plus going to the court 5 years, it takes 10 years.
G.
So, first challenge is court interference. And this court interference is known
G.
to the outside world, and they know that ours is a hopeless court system. They know that this court system is beset with delays and procedures and so on and so forth. Therefore, they prefer to take their arbitration matters outside than to come this country. This is one, court interference.
G.
Second challenge is of delays.
Time consuming.
What happens is even before you start an arbitration, you start with a civil code by a Section 9 application. Section 9 application is an application for grant of interim relief. Before arbitration starts.
G.
And can you believe that application takes years to decide? Arbitration is nowhere.
G.
In the courts. Suppose you lodge it in the district court. The district court then they will appeal in the High Court.
It will travel its own course.
Supreme Court, travel own course. No arbitration.
G.
Now then we changed the law and made it that no, within 3 months arbitration must start even if your Section 9 application is running, but nobody is implementing that also. Similarly, we made an amendment that arbitration proceeding must be completed within 1 year with a proviso that if both parties want to carry on for more time, then they can do it for 6 months by mutual consent. Then what happens on ground is that parties and their lawyers go on extending. So it is not 1 year also. Second is enforcement. Enforcement is after you have got an award, then the presumption and hope was that it is final.
But it is not so.
But on ground it is not so.
Ji.
Why it's not so? Once an award is made by me as an arbitrator, you as a party have a right to object to it.
Ji.
Now that objection you take under section 34 of the Arbitration Act in the court.
Ji.
Now suppose it is in the High Court. Then section 34 application you have to make in the High Court seeking setting aside of this award.
Ji.
So where is the award? Award is in flux. It's not implemented.
Right.
Now that section 34 application becomes a proceeding which goes for years and years and years up to Supreme Court.
Ji.
You file an application for section 34, court will invite objections.
Ji.
You first issue a notice, call for a record, invite
The
objections.
entire process has to be gone through.
Rejoinder, then reply, and then this and that, and someday it is decided. When it is decided, then appeal again.
Ji.
Now it goes on, so there is no enforcement.
So this second issue is of delay.
Delay in enforcement. Similarly, process of employment. See, we are signatories to New York Convention of Recognition and Enforcement of Awards. Under that, our domestic courts must respect an international obligation.
Ji.
If you get an international award here, it will never be implemented.
Ji.
So people run away. People say where to go. Now similarly, we don't have an institutional arbitration here. We are going by ad hoc.
Ad hoc
arbitration. Ad hoc arbitration is what? It's again a scandalous thing. Ad hoc arbitration is where two parties execute an agreement making someone as an arbitrator, or court appoints that under section 11.
Former judge or anybody.
Whosoever. Now mostly courts appoint former judges and so on and so forth. That's called ad hoc arbitration. Now what happens in ad hoc arbitration? In that all stakeholders, lawyer, party, arbitrator, all are interested in prolonging.
It suits their interest.
With every sitting they get out their fee. And as long as you go on getting your fee, you go on dragging on. So in ad hoc arbitration, in institutionalized arbitration means if there is an institution like we have in FICCI, that Arbitration Council of India, we have in Delhi High Court also Delhi Arbitration Council. Now in that, what is done is that everything is decided by that institution. They have their own panel of arbitrators. Now they have their own rules for fixation of fee. Then what is best, which I like about that, is they don't pay you the fee while starting your arbitration. They will pay the fee after you pass the award. Now, because of that, everybody works for a timeline. No, the sooner we do it, the better it is. So that institutional arbitration is not taking roots in our country at all, and that is also what scares away the investors, foreign investors in coming to here. People prefer to go to Singapore or Hong Kong or somewhere else. I am on the point of hub.
Right.
So Singapore is today a hub. Similarly, we have a problem of pool of arbitrators. Pool of arbitrators is in our ad hoc arbitration. It is our former judges only. Now those former judges are not experts in some fields of arbitration. Now those also give dates and tarikhs and this and that and that and that. So what is needed is that this pool of arbitrators must be trained. And it must be diversified. Diversified include people from other fields also, to make it balanced. So that is not happening. Similarly, so many challenges, but the worst of it is that we have not made any distinction between a court system and arbitration. We have not made any distinction between a civil suit, which we run in Tisazari for 30 years, and arbitration, which we run in some 5-star hotel for 15 years. With the result that I don't see any immediate prospect of
It
our
becoming
country
a hub.
becoming a hub of arbitration.
Thank you very much. A very practical and wise expression of views with regard to the hope that India should become a hub of international commercial arbitration. I am sure that these views would be listened by the authorities to be, and the set of people like international, Arbitration Council of India, and some way out would be resolved. Thank you very much, Justice Khan,
Thank you,
for all your time and patience and a clear enunciation of the law points involved in the various questions that were raised together with your huge experience. Thank you.
Thank you, Jal Sahab. Thank you very much.